Ma, prendi la losa qua. Está bien.
Give me just a moment. All right, ladies and gentlemen, I'm Judge Wilson. I'm about to start calling the dockets. For those of you following from home, we're now entering, I believe it's the 5th week of I'll have a computer in 2 weeks, and I am at this time not able to use my Acrobat and Zoom at the same time. So I've got a paper docket, and I will take a recess after I call the docket and go and get my private laptop from the house. In the meantime, I'm going to call the dockets. I'll ask for announcements from the attorneys. And I want everyone to listen carefully, people who aren't attorneys. If you have an attorney, your attorney will answer for you. So the only reason you would answer if you have an attorney is if for some reason your attorney is not present to answer for you. So give them a couple seconds. If nobody answers and you don't see them, then go ahead and speak up. But hear from everyone after their attorney has already answered saying, here I am. If I ask you to answer because I don't see you on the several screens I have of participants, then go ahead and speak up. Apart from that, please keep your electronic devices muted all the time so that we don't get a bunch of background racket. I will begin with the criminal dockets. And look in chat, is the court administrator's office on? Looks like Ms. Riley is on.
Yes, Judge, I'm here.
Okay, and have we
Sorry.
posted, okay, yes, you posted trial tracks, all right?
Yes, sir.
So I'm gonna ask, I may ask you to go ahead and repost them in just a moment because everybody who checked in after 8:56 when you posted them won't have a copy. Just
Sure.
attorneys, or let the attorneys know if you haven't been here recently, we're going back to regular docket beginning the first Monday in May. The judge on the circuit will appear in court in person, at least most of the time. And beginning the first business day in June, we're going to resume jury trials. So unless you have an MTR or unless you have some special dispensation from me on a criminal case, you are not excused until that case has a setting which gives it a pretrial date if one is needed, and a docket call and a jury selection date. And attorneys need to post those in chat to everyone so that the clerk and the administrator and I get to see them in this format: cause number, name, and then the dates. The reason we do that is we save the chat from all of these court hearings, and that way we have a written record that's easy to read of who announced when they were supposed to be back, because we do not have the little handwritten carbonless copies for people to sign off on. All right, with all that done, State versus David Greenwood. Mr. Barrera? All right, no show?
Your Honor.
Your Honor, I'm present for him. I'm present for the office. Mr. Greenwood is in the hospital. His wife is in labor.
Okay. All right, I'll mark you green. Lisa Powell.
I'm present for her as well.
Okay, that's early termination.
Yes.
All right. Derry Lewis.
I'm present for that case as well. He should have reported to probation.
Mr. Flores.
Let me check, Your Honor.
Okay. And what do we have today?
That's a motion to revoke probation. He has 2 cases and we're asking for a bond to be set.
But he's not in custody?
No, he reported to probation though.
Okay.
Or should have.
Has he
It's
been
not here, Your
arrested
Honor.
on those charges somewhere?
No, not yet.
He is not at probation, Your Honor.
Okay, and was he ordered held without bond?
I believe he's remanded without, Your Honor. Yes.
Yes, sir, on both cases.
Okay. Bojavan Serta.
Custody, Your Honor.
All right. We heard from Mr. Briggs.
Yes, sir. He's doing a plea in Atascosa first.
Thank you. Are you okay?
No, sir, I've lost my voice.
All right. Arwen Mitchell.
I'm present for her, Your Honor. Good morning. She should be on. Send her the invitation. Miss Mitchell, would you announce, please? I'll find out where she's at, Your Honor, and I'll inform the court.
All right. Mark her no show. Nicholas Moreno. Custody.
Yes, Your Honor, and that is a motion to reduce bond. We should be ready by about 10:30. I'm rounding up the witnesses.
Okay. David Mora.
He's present with counsel, Your Honor.
Your Honor, you just skipped page 2. You're on page 3.
All right. Give me a moment. We'll go back to page 2, or I'll bring some duct tape from the house. The back has fallen off of the printer. So instead of neatly collating the documents when I print them, it scatters them across the floor. And I had to try and put them in order in a rush. State versus Jesse Nelson.
I'm present for him. I gave him the invites, Judge. I don't see him on. I'll check with him. I'll try to reach out and get a hold of him.
All right, no show. Jesus Lopez.
Present for him, Your Honor, and he's on the Zoom. Jesus, would you announce? Unmute yourself.
Yes, present.
Okay. I'll talk to, this is a trial case, Your Honor. I'll talk to the prosecutor.
Dennis Lee Smith.
Your Honor, that is going to be a plea. Paperwork has been filed and accepted. So whenever the court is ready on that.
Okay, where's Mr. Smith?
He's in custody.
I have emailed everything to you, Your Honor.
All right, well, I'm gonna have to go get a computer before I can work on anything. All right, Bojavan Serta still in custody. Kenneth Carlisle.
He's prisoner at our probation office.
All right, Mr. Anders just checked in, I believe.
Yes, Your Honor.
Okay. What announcement?
I'd like to have a breakout room, but I believe that we'll be able to reach a solution today.
All right, let me go ahead and make Ms. Riley I can find her.
Your Honor, Jesse Nelson just showed up here in our lobby.
All right, thank you.
I'm under L. Riley, Judge, if that helps.
It's in the
Yes, I
little
just found
attorney
you.
visit room.
We are. And here comes Arwen Mitchell. But I can't admit her. All right, I'll mark Mr. Nelson present. State versus Joseph Marshall.
Your Honor, that's going to be a trial case. I'll put the new dates in chat. Joseph, are you there? I sent him the link.
All right, no show.
I'll check him.
David Mora is present.
Yes, Your Honor.
All right, Ms. Mitchell. I'll mark you
Yes, my
present.
thing wasn't on mute. I'm sorry.
Your attorney's here. I will mark you present. All right, Stephen Collins.
Your Honor, I'm here on his behalf. He has 3 or 4 cases. He should be online. I gave him the link. Stephen, are you online?
Yes, sir. I'm here.
Okay, I'll mark you present.
Can you put us on the trial doc? docket route, Your Honor. We'll try to work it out on the next pretrial.
No, sir, you need to post whatever dates.
I understand. I'm gonna do that.
Yeah.
Okay.
Shaina Peril.
Hi, yes, I'm here.
All right, I'll mark you present.
Sorry, Judge, I'm here.
Jose Arroyo.
He's present with counsel, Your Honor. We will confer.
Okay, is he with you? Is he online?
He is. No, I'm sorry, Your Honor. He is the participant online identified as Jose. I recognize him from the video.
Got better eyes than I do to see a silhouette.
Oh. I did a little earlier.
All right. Fernando Cantu Jr.
Morning, Judge. Robert Gear for defendant Fernando Cantu. My office is on the phone with him right now, guiding him through the log-on process. So you can recall that. He should be logged on here in 5 minutes.
All right, I'll mark him no show for now. Jose Barrientos III.
Judge, my understanding is that Mr. Langwell has a vacation letter on file.
And Mr. Langlois has done a notice of appearance on this case. Mr. Barrientos has 2 cases. He is here in our Zoom room.
Okay. Let me ask just the coordinator's office to give us a date for him to appear on pretrials after his vacation letter, and we'll let him, Mr. Barrientos, know that here in court. Mike Nava.
Your Honor, I'm here for Mr. Nava. He's been on the docket a couple of times in the last few months, and I've announced pretty much the same thing as I have for today. I have not been able to make any kind of contact with him, let alone get a waiver on file. So we made contact with a couple of family members, but they haven't really had any more success than we have. So we're working on it, but that's probably a no-show for today.
All right, I'll mark him no show. Genevieve Salinas.
I believe she's in custody, Your Honor.
That is correct.
All right, and Stephen Collins again. What was his announcement? He's present, okay. Anthony Garza Jr.
Good morning, Your Honor. Sylvia Rodriguez on behalf of Mr. Garza. He is present. I think he's on page 3. I've already posted the May 5th, the May 12th, and then June 28th on chat, Your Honor.
Okay. What format did you post them in?
I posted them on chat, Your Honor. I spoke with Miss Whitney. She was good with those dates. And then I posted them on chat for everyone.
Okay. I'm gonna ask that in the future, if you would post them just with the cause number, name,
okay,
and if there's extraneous chatter, put that at the end. Because again, what happens is we get a text file of the chat, and if everybody posts it in that direction, you can just run your finger down the line and see exactly who posted what. But if it's posted in different ways, you have to stop and read every single line to see what's going on. So I'll mark those dates down. We'll see you soon. Elias Cerna.
Same announcement on Mr. Serna, Your Honor. I believe he's up here on Galaxy Note number 10. Mr. Serna, can you wave or say good morning? He's going to unmute. He's waving, Your Honor.
Okay,
he's a gentleman with a beard, glasses, waving.
Yes, okay. I don't see him now, but that's fine. I saw the Galaxy Note 10 earlier.
Thank you, Judge. And I did the same thing. If you'd like, I can go back and correct it and just put cause number in the date.
That's fine. Just from now on, please do it that way.
Yes, sir. And I have nothing further. May we all be excused, Judge, meaning my clients and myself?
Yes, once you've posted the dates correctly, everyone's attorneys and clients are excused. Nathan
Thank
Morales.
You,
Mr. Vargas.
Yeah, Your Honor, and he's still in jail.
Okay. All right.
Where is he in custody?
I'm sorry, in Bear County. I'm sorry.
All right, and this Mr. Barrientos again. Now, did Richard Langlois, I'm sorry, did he appear in this case or not?
No, sir, he has not submitted a notice of appearance for this case. I did visit with Mr. Barrientos, and he said he plans on retaining him for this one as well. Mr.
Okay,
Baird
All
right, thank you. That's great, Mr. Baird.
Yeah, yes, Your Honor. I'm as far as I was aware until just a moment ago, I'm here for Mr. Barrientos on both cases, but I do see where I have been replaced. It appears on the older of the two. I spoke with him earlier this morning so we could get the waiver of arraignment on the new case on file, and he mentioned nothing about new counsel. So I assume
Okay, and that's fine. And you're the attorney, and lesson until Mr. Langlois files something.
And waiver is on file, Your Honor, or it should be in the queue for the.
All right, thank you.
It is.
State versus Hilario Hernandez.
Counsel's present, Your Honor, and he's in the Wilson County Jail, and he signed a waiver of arraignment, and we'd like to put him on the trial docket, trial track.
Okay, does he already have trial dates or not?
No, I'm using these the ones that are posted on chat.
Okay, okay, but are those the dates that were on his waiver?
Yes.
Okay, then he can just remain on docket. All right, anyone else told to be here today on a criminal case only? Okay, I'll release the attorneys for the state. Any attorneys with no civil matters in the docket to confer? Ms. Riley is the host. If you need to confer, please check with her or get with her on breakout rooms. Civil docket, Wilson County. In the interest of Madison Balmus, a child.
Your Honor, I received the signature back this weekend, so I can post it in chat if you want, or wait until you get your computer.
Why don't you wait?
You want me to wait?
Yeah, because if I sign it on a different computer, you're going to have to repost it. So yes.
Okay.
All right. In the interest of Nathaniel Kufas.
Your Honor, I'm present for that, and my client is present. I do not know if respondent is here. If we could approach after the call of the docket, just to explain.
All right. Is Kimberly Kufas here? I thought I saw her trying to log on, but maybe I did not. Kimberly Kufas. All right, we can confer shortly.
Thank you.
9568, in the interest of HKK and NK children.
Your Honor, petitioner is present. I am not sure if respondent is here. Alexandra Ellsworth.
I am present. I am here, Your Honor.
Your Honor, we're here on a modification of possession and access. I'd be happy to meet with Miss Ellsworth in the meantime.
All right, please. And okay, and the iPhone, that's Miss Ellsworth?
Yes, sir.
Okay. Any relation to Hank Ellsworth?
I'm sorry, say that again?
Are you any relation to Hank Ellsworth from Corpus Christi?
No, my grandfather, Hank, was from South Dakota.
Okay. All right. Ma'am, I've marked you present. I've changed your name on the screen. You should receive an invitation shortly to a breakout room with Ms. Nettles. What a breakout room is just a separate electronic room that you go to where it's just the two of you to discuss this matter. I'm just going to ask you to discuss what's going on. All I know is that we have a case on the docket. Ideally, it'd be good if you could work out a solution. If you can't work out a solution, I'll ask you to at least narrow whatever you have disagreement about, and then come back and tell me if you're ready to proceed on a hearing on that issue.
All right.
In the interest of Thomas W. Gonzalez, a child. Ms. Castillo. Well, she was here a moment ago.
She's unmuted now, Judge.
Okay, yes, ma'am.
Ms. Castile?
Yes, I'm there on the Krause case.
Oh, is this a previous representation apparently?
This was back from 2019. Is this in the interest of 4 Krause children?
No. This is Thomas W. Gonzalez, a child.
No, Judge, I don't think, yes, I'm sorry, I do represent them. I don't believe we have service yet. Will you put that on recall, please?
Okay, reset on request. Wilson County versus Ruben Morales. Is that all you had?
No, sir, I've got the Victoria Krause, Sable
Okay.
Krause, the Krause children with the Attorney General.
Okay, Ruben Morales.
Good morning, Judge. I'm
Christine,
here
will you
representing the claimants in that case. This is Shade Ogunbade Pfeiffer.
Right.
And you asked us to return because there was an attorney that filed a motion after our motion was filed. And we
Yes.
notified her, Attorney Delilah, and she's signed off on the order. And that order has already been e-filed for the court. The county's attorneys don't have any objections to that proposed order from what I recall from the last hearing. I'm not sure if Attorney Garcia is here today.
He is.
I'm present, Your Honor, and no objections.
Okay, well then I know Ms. Kruger came in and said that she had forwarded a number of stuff to the items to the coordinator for the judge's queue. I will look at that as soon as I get it and sign off on it.
Thank you, Your Honor.
Yes, ma'am. If that's all you have, you're excused.
That's all I have.
Deborah Hill versus Michael Johnson.
Your Honor, we resolved that. We submitted a Rule 11 agreement.
Okay, so you resolve the need for a hearing today, or it's going to be disposed of completely?
I think it's going to be disposed of completely. It will be disposed of.
And do I need to sign something to make that happen, or?
No, I think, well, no.
Okay. All right, I'm going to ask you to make sure that it's resolved in a way that we don't have to put it on a DWAP docket in the future. One day, the Texas Supreme Court will lift the ban against dismissal without prosecution dockets, and we had just run one when they put that ban in effect last year. So I shudder to think how long it's going to be.
Okay. I'll submit an agreed order, but this Rule 11 agreement should dispose of all issues.
Okay, excellent. All right, and here we are in the marriage of Derek and Colleen Krause and the Krause children.
We're here.
Judge, I'm present for Mr. Krause. Derek?
Yes, Your Honor. Attorney General is also here for that case, Your Honor. If we could confer with Ms. Castile for a moment, I think that would clarify what we're doing here today.
That'd be fine,
Hey,
Judge.
And I'm sorry, who answered on behalf of Mr. Krause?
I did, Carter Castile.
Okay, another attorney answered, I thought. Was it just you?
Just me, Edward Balderas for the OAG, Your Honor.
Okay. And Lauren Reed and Sam Fugate are no longer in this?
Judge, that was a divorce that had been filed, and I don't know if Mr. Fugate is still representing Colleen Krause or not.
And
Okay, so
Maybe
now
it's
it's
the
just,
AG.
all right, so it's no longer divorce, it's just in the interest of the children. Okay, we'll edit the style. Mark, you conferring, and yes, Ms. Riley is doing the breakout rooms.
Thank you, Judge. And on that other matter, we did not have service on Mr. Gonzalez. We'll try to reset that once we get service.
Okay, excellent. Vanessa Martinez and Maria Mendoza versus Sarah Freeman.
Ethan Shaw for the plaintiff, Your Honor.
And Zachary Edwards for the defendant, Your Honor.
And what do we have to hear?
Motion to compel.
And Your Honor, it might behoove us to confer a little bit more. I think we could probably narrow some of this down and before we come back in front of you.
Okay, I would appreciate that. I ask you to get with Ms. Riley on a breakout room. The matter of the marriage of Janice and Tony Willis.
Yes, Your Honor, good morning. Evelyn Huron for Ms. Willis. And I think we're going to confer, if we may. Ms. Lauren Thompson is opposing party.
Yes, I'm here and we want to confer. Thank you.
If we could get a breakout room, Your Honor.
All right, Ms. Riley is the host, so she's doing those, but yes.
Okay.
Matter of the marriage of Jacob and Alyssa Petrie.
Yes, Your Honor, this is Jacob Petrie.
Okay, and are you ready to proceed?
Yes, Your Honor.
All right, I'll mark you A. I will, probably the first self-represented case I take up. The matter of the marriage of Tammy and Melvin Pfeiffer.
Yes, Your Honor. This is Tammy.
Yes, Your Honor.
Okay, and are the two, all right, are the two of you ready to proceed?
Yes, sir.
Yes.
Okay, and, all right. Okay, give me just a moment. Okay, I'll mark you as B. And in the matter of the marriage of Susan Presley and Jeremy Ryman. Mr. Cedios?
Your Honor, Council's present on behalf of Susan Raymond, and I saw Stephanie Pierchard.
Yes, Judge, I'm present for Mr. Jeremy Raymond.
All right. All right, Mr. Cedios, Ms. Shearhart, I will mark you conferring.
Sure. We just need a breakout room.
Yes.
I'm sorry. Yes, that's fine.
Okay. And, all right. Okay, anyone else told to be here today? Your case was not called.
Your Honor, Joseph Lawrence Marshall is now online. I gave him the wrong link for Atascosa County, so I apologize for that. Joseph, can you announce?
I'm here, Your Honor.
Okay, I'll mark you conferring.
Thank you.
Your Honor.
Could you hear me?
Okay, multiple folks chatting at once.
Your Honor. Oh, I'm sorry.
All right.
Your Honor, if Miss Riley could put Mr. Krause into the same breakout room number 2 with Miss Castillo and myself, that would be very helpful.
Okay. What's his first name?
Derek.
Derek
ma'am.
Krause?
Yes,
Okay.
yes, ma'am.
Thank you.
All right, and Ms. Riley, these are the only 2 dockets I had, is that correct?
That is correct, Judge.
All right, seems like we've got folks here who didn't answer. Anyone else told to be here today, your case was not called? All right, and is Ms. Tapia in a breakout room?
Could you hear me, Your Honor?
Hey, who are you?
My name's Fernando Cantu. My attorney's Mr. Gear.
All right.
That's my client, Judge. We were on the phone with getting him to log in. He's on the top of page 2, I believe.
No, he's
Okay.
bottom of page 3, top of page 4.
Top of page, okay.
Okay, see, the thing is, the pages are not universal.
Okay.
One person may be page 3 for someone else. That's why it's no help when you tell what page it's on this. Okay, I'll mark you present.
Thank you, Judge.
All right, and then we have a Zach coming in.
He's an attorney, Judge, I believe.
Okay.
I think. I thought I put him in a breakout room with Ethan Shaw, actually.
Oh, well, he may have gotten kicked out.
Your Honor, sorry, I think y'all are talking about me. I did get kicked out.
Okay. I'll put you back in that room.
Number 3.
Yes, I'll put you back in there, Judge,
Thank you, ma'am.
Mr. Edwards.
Appreciate it.
All right, and Ms. Tapia, you needed to speak with me in a breakout room?
Yes, it was just to let you, as far as what you wanted to do today with regard to getting Ms. Wright notified about today. And I can let you know right now. We can do in a breakout room, whichever you prefer.
Right here is fine.
That's fine. When I did send the motion to modify and request for additional temporary orders, I did mail that to her, certified mail and first class mail with today's hearing on it. The court issued the ex parte TRO out of abundance of caution. Not only did I mail those to her, certified mail and first class mail, I had the district clerk's office issue the precept and the notice, and we attempted to have her served. I did file a motion for substituted service, but that did not make its way to the court to get signed before this weekend so we could get it posted on her gate. So I don't know, all the certified mails, she has not picked up any certified mail at all. I don't know if the court, she's never filed an answer or anything. I don't know how you would wish to proceed. We can, if you'd like, we can reset and get her served with the ex parte TRO and the notice of today's, or reset this and send it out again, and trying to get her served, or I don't know how the court wants to proceed, Your Honor. I think the judge froze.
Mr. Leday, are you on?
Yes, ma'am.
I had sent you to breakout room 4 with Daniel Rodriguez. Did you already speak to him?
I have not. I'll go there right now.
Thank you. Does anybody else need a breakout room?
Lori?
Yes.
Cindy?
Yes, ma'am.
Ms. Riley?
Hold on.
I need a breakout room with the clerk's office or one of their Zoom rooms.
Okay, and is there some?
Ms. Riley, we've left the breakout room. Edward Balderas and I left one.
Okay, are y'all done then?
Yes, ma'am.
Ma'am, we're
Okay.
done and just need to report to the judge.
Okay, he's having some computer issues, I believe, so.
Okay, Lori, the breakout room Ruben needs is our WC Dist court.
Okay, let me see if I can find that real quick. WC Discord, okay.
Okay, and then I was going to ask you about Jose Barrientos. He's the one that has Langlois and Baird. Michael Baird has posted dates for the case that he's on right now. Can we just put those same dates for Mr. Langlois?
Sure.
And I'll get Mr. Barrientos to sign an order setting.
Okay, that's no problem. Let's see.
So it's the trial track.
Okay, and what was his name again? I'm sorry.
Jose Barrientos. He has
Barrientos.
cases 2008 206.
Okay, and it's going on the trial track, you said?
Yes, we're just going to go the 5-5, 5-12, and 6-28.
Okay. Okay, I see it. Okay. Anybody else need a breakout room?
Yes, if I could get one eventually with the probation department to speak to my client.
Okay. So probation, where would that be?
I don't know if they're in a breakout room now or if they're called.
Cassie.
Oh.
I don't know.
They were on here.
I can pull him into the office and y'all can give us a breakout room for him. It'll be the screen labeled defendant.
Defendant.
Yes,
I
ma'am.
don't have a screen. I don't think like that.
Let me go and make sure that computer's on.
Okay, yeah, I don't have one for defendant, I don't believe.
Okay. I'm gonna go double check.
Thank you, sir.
Lori, the judge just left to go get his laptop at home.
Okay, good deal. Thank you. All right, Mr. Andrews, as soon as I get that set up, I'll get you in a room.
Yes, ma'am. Thank you.
Hey, Andrew, are you on?
Ms. Riley,
Yes, ma'am.
Carter Castile on that Kraus case. I don't know
Yes.
where Eddie went, but we've resolved everything and I'm gonna just non-suit the divorce.
Okay.
Do I need to wait and report that to the judge or may I be excused?
I mean, I would report it probably to the judge just to be on the safe side.
Beg your pardon?
I would probably go ahead and just wait for the judge to get back and
Okay,
report that.
that's
If
fine.
you want
I'll
to,
stay right here.
or you can,
I'll be right here.
Okay, thank you.
I'm still here too, Carter. We can wait. Yeah.
Mr. Andrews, I'm gonna go ahead and place you and your, the probation office that's under the defendant in a breakout room. Ms. Pfeiffer, your case hasn't been heard by the judge yet. You need to wait till the judge comes back.
Yes, ma'am. Thank you.
You're welcome. Is everybody in a breakout room that needs one?
Yes, Ms. Riley, I'm sorry. Can you give me a breakout room with the jail and Nicholas Moreno?
Sure.
Thanks.
Let me call for him.
I'll go ahead and assign you out to breakout room 10, and then when he gets to the jail, then they can get him in there.
He's on his way now.
Thank you.
You're welcome.
Cindy, do you show a waiver of arraignment on the Hilario Hernandez case, the 2103 63W case, CRW case? I don't show it in the e-file.
Let me look. Andy was going to be dropping it in. Let me see if it's there.
Okay. I don't know what dates are on it, so.
Okay, it is not in e-file yet, Lori, but Andy had said he was putting the current trial track dates on
Okay.
it.
Okay. I just want to make sure because I didn't have the dates listed on. Well, I have them all listed here, I guess, but.
The 5/5, 5/12, 6/28.
Okay. I'm gonna step away from my desk for just a moment.
Mark Leday,
Yes, ma'am.
I've sent you two different emails. His big bond is not on today's docket. I just sent you a second email.
Okay, I've got them.
Okay.
Thank you, Cindy.
I'm back. Does anybody else need a breakout room or anything?
Mark, are you available for a breakout room?
I am.
Ms. Riley, may I be placed in a breakout room with Mr. Ledette? Thank you.
Lori. The waiver on
Yes, ma'am.
Hilario Hernandez, I just put it into the queue.
Okay, I'll look for it. Thank you so much.
Knock that one piece out right away. Okay, I'll start with one.
It was just dropped, nothing?
Well, the second one. New grant relations.
Gotcha. Okay, thank you.
Judge Wilson, I have an announcement. Two announcements, actually. On David Greenwood on page 1, I sent a note to the court coordinator and also to Mark Leday.
Okay, ladies and gentlemen, I'm back after a fashion on my personal laptop, which, if you haven't been following the saga, is my old laptop, which I has as a backup because my newer laptop was not working well, and I took it to a shop in Jordanton, and they made it work not at all. But I'm here. So what announcements do we have?
Your Honor, I have two announcements.
The reason you can't see me is because apparently I dropped this old laptop or something at some point, and the camera not only is in black and white, but it's skewed sideways. And in order for you to be able to see me, I have to twist it, the computer sideways. So I'm just going to sit in front of it and y'all can't see me. I'm sorry. So what announcements do we have?
Your Honor, I have two announcements for you. This is Dan Rodriguez.
I'm sorry?
This is Dan Rodriguez. I have two announcements for you.
Yes, sir. Go ahead.
David Greenwood on page 1. I have sent a doctor's note to Lori and also to Mark Leday. He's out today because of his wife is in labor. Mark does not oppose us continuing this case and keeping it on the trial docket. So I'd ask that you.
All right, hold on just a minute, sir.
I can post it to you too, the doctor's note.
All right, give me just a moment. I have a speaker issue. All right, no, If Mr. Leday's fine, that's fine. If you'll just post whatever dates you need to post in chat, we'll excuse your claim.
I've done that already. And on Lisa Powell, we have an agreement to early terminate her probation. And I've sent that order to you.
Okay, how?
I also emailed it to you, Your Honor. You can find it in your email.
All right, if y'all would post that in chat. The issue is because this is my old laptop, which has been sitting for 2 or 3 years, I don't have access to my official email on it. And
Okay, Dan, I'm dropping it onto the chat.
Thank you. I'm hoping
Okay.
to get that set up today. I'm hoping to get.
I think I'm losing my voice too, Cindy. I don't know what it is.
What's that?
I said I'm losing my voice as well, like Cindy has. I don't know if it's like allergies or what, but
Okay, it's contagious over Zoom.
yep.
Sounds like we have a class action lawsuit.
Okay.
Against Oak, I think.
I just posted it, Judge, to chat.
Okay.
Good morning, Your Honor. We have an announcement from the civil docket.
All right, give me just a moment to get this opened and sign it. So I'm just doing, okay, and you're, all right, well, it's opening. Okay, what's your announcement?
It's on the Willis and Willis case.
Yes.
And we have an agreed order to go to mediation. And I can just email that or e-file it later.
That's fine. If you want to e-file it. All right, Janice and Tony Willis. And do you need a date, or I'll just put reset on request, mediation order?
Yes, that's correct. And I'll send you that order. I'll e-file it.
Okay.
Thank you.
Judge Wilson?
Yes, sir.
Yeah, this is Ethan Shaw and cause number 20090 Mendoza versus Sarah Freeman. We have an announcement.
All right, go ahead.
That's a motion to compel, Your Honor. I have conferred with defense counsel. I'm going to give them an additional 7 days to get this information. I think they're having some client difficulties that they claim they now have been able, they believe, to resolve. And that I should have this information here within the next 7 days.
Okay, excellent.
And Your Honor, this is Zach Edwards for defense. That all of that is correct.
Okay, excellent.
So Judge, you don't have to listen to a motion to compel, and can we be excused now?
Yes, sir, you're excused.
Thank you,
Your Honor.
All right, anyone else have an announcement?
Yes, Your Honor, we have an announcement on the interest of HKK and LNK children. That is CVW 1600568 on this. And we have made the agreement to for temporary orders for supervised visitation on the 1st, 3rd, and 5th Saturdays of the month. And Mr. Kent, my client, or his parents will supervise visitation. And this will continue until further order of the court. I just wanted to stipulate what it was on the record. And that Ms. Ellsworth would take a 10-panel hair follicle test within 6 months of today's date. And if not, we would just set this for final orders. And I believe Ms. Ellsworth should be on.
All right.
Yes,
Ms.
Your
Ellsworth?
Honor, I apologize.
Okay, is that your agreement?
Yes, sir.
Okay, do we need an entry date?
Your Honor, I told Ms. Ellsworth that I would send this over to her today, and so I'll just forward it over to the court today once we get everything signed off on.
Okay, all right, so I'll put reset on request, agreed order to be filed.
Thank you, Your Honor.
All right, y'all are excused. All right, any other announcements right now?
Judge Carter Castile and Eddie Balderas, we've resolved the Krause matter. And I'm just gonna non-suit the divorce and then, because they're living together and they just apparently put it on to check on him. Now Eddie was staying around as far as I knew, but that was our agreement.
Sorry, I was on mute, Carter. Yes, that's right, Your Honor.
Okay.
Thank you,
All right,
Judge.
so was the divorce finalized then, or?
No, Your Honor, it was never finalized. It's going to be non-suited, and the state had intervened in that divorce, and we had set this for a hearing to try to get something moving on it, and it turns out that the parties reconciled in the meantime, so the divorce is no longer necessary.
Okay, excellent.
Thank you, Judge.
All right, y'all are excused.
Thank you, Your Honor.
Any other announcements?
Your Honor, I did not know how you wanted to proceed with the Kufis right matter. As I had explained, she's never filed any answer or anything. When we filed the motion to modify and to request for additional temporary orders and the ex parte TRO, I did mail that to her, first class mail and certified mail, again, out of a error on.
Ms. Tapia, I mean, I'm always, she was served with the initial paperwork, is that correct?
Correct, by posting it on her gate.
Okay. All right. I mean, I'm confident that Ms. Wright is aware of this and knows how to get in touch with you, knows how to get in touch with the court.
Okay.
So I'm willing to proceed, and I'll take judicial notice of all of the previous testimony and affidavits and filings in this case. And do you need to put on additional evidence, or you just have a proposed order?
Well, Your Honor, we're requesting that because the previous order was joint managing conservatorship. We're asking for sole managing conservatorship and several other things too. So I would think that I would probably need to put on some testimony for the court to find that that's in the best interest of the child.
Okay. Any other announcements before we start that?
Judge, Stephanie Shearhart here on the Presley Raymond divorce. We may need a hearing this afternoon, but we're currently still conferring.
All right, thank you.
Thank you.
Your Honor, on Miss Lisa Powell, is she excused?
Yes, I haven't signed her. I haven't signed her PDF yet because I haven't signed into Acrobat in several years on this computer, and I've got to figure out what my new password is. But I will get that done and get it signed and posted to Miss Kruger in chat, or Miss.
Okay, but you're okay if I excuse Miss Powell?
Absolutely.
Thank you, Judge. And I also was waiting on, I'm sorry, Judge, I was waiting on Derry Lewis, but I don't think he's shown up to probation. And that's my last. Andrew is on.
He has not.
Okay,
and that's my last client, Your Honor. May I be excused?
Yes, sir. And actually, Ms. Riley, I forgot that it makes me the host again whenever I re-enter. So I have just made you the host. If you'll make me the co-host, I'll appreciate it.
Yes, sir.
All right, Mr. Kufis, you've previously been sworn. If you'd unmute, go ahead, Ms. Tapia.
Thank you, Your Honor. Mr. Kufis, we were in court back in February when we had the snowstorm, and at that time, you made arrangements to transport your son to the Nexus Medical Facility in Houston. Is that correct?
Yes, it is.
And did Ms. Wright ever contact you or cooperate with you in transporting your son to the Nexus facility?
No, she did not.
And in fact, we had to get rid of attachments so you were be able to pick up your son and transport him there. Is that correct?
Yes, it is.
And you had to appear at the residence with a constable and some deputies, and you had to arrange for an ambulance to be present. Is that correct?
It is correct.
Okay. And when the ambulance got there, what happened when the ambulance got to the residence?
Law enforcement already had contacted Kimberly Wright, presented the orders. Ambulance got there. My special needs son, Nathaniel, was hurriedly prepared for a trip to Houston. Meanwhile, a medical technician, also whom I paid for, performed COVID rapid response nasal swabs to Nathaniel. As per admission conditions for the hospital, he fortunately tested negative. He was bundled up into the transport ambulance, and I followed the ambulance to the Nexus Children's Hospital in Houston, a drive of about 200 miles.
Okay. And were there any incidences or anything with getting Nathaniel to the hospital, or when he got to the hospital, or anything like that?
No. Fortunately, Kimberly Wright did not do anything to interfere. There were at any one time as many as 4 law enforcement officers there. We got Nathaniel out and were able to make the trip. I had already made arrangements with Nexus hospital staff for his readmission. And at that point, things went fairly smoothly. Again, Kimberly Wright did not cooperate in as much as she did not interfere, and we were able to get him there.
Okay. And that was on March 4th when he arrived at Nexus. Is that correct?
Yes, it is.
Okay. And then on the evening of March 6th, did you receive a phone call from Nexus?
March 6th. Yes, I did. I was still in Houston. I received a phone call that my son Nathaniel, who by the way is 17 years old, he's 5 foot 11 inches tall, and at that time weighed approximately 324 pounds of morbid obesity, and is also on the autism spectrum. He had a tablet conversation with his mom, during which something was said that he went into a very violent autistic meltdown. He was throwing a trash can. He turned his bed over and had to be manually restrained by a number of staff members, and was also administered sedatives. And it took approximately 2 hours to bring him down.
Okay. And we also advised that Kimberly Wright had phoned the Houston Police Department regarding Nathaniel.
Yes, after I had received 3 or 4 phone calls by the supervisory nurse, even as Nathaniel was being restrained, I received a phone call from the receptionist at Nexus Hospital, informing me that 2 Houston police officers were standing in front of her, and one of them wished to speak with me. I was on the phone with the patrolman for 13 minutes. He informed me that Nathaniel's mother, Kimberly Wright, had phoned the Houston Police Department to report that the Nexus Hospital staff was abusing her son. And the officer asked me if I would consent to allowing him and his partner to examine my son for signs of abuse. I knew that this was not true, and I did not give consent. And I explained to the officer the district court action in Wilson County, Texas, and the events leading up to this. And he seemed satisfied with the explanation, and did not further ask. But he did say that Kimberly Wright
had given a callback number, but would not answer the phone when the police called her back.
Okay. And then were you advised on or about March 24th of another incident involving Nathaniel reacting to something that Ms. Wright had done?
Yes, there had been yet another tablet conversation, one of those internet-enabled devices, and something occurred during the conversation, and he went into yet another a violent meltdown and had to be restrained by several members of the staff, not just one or two people, and also that tranquilizing drugs had to be administered.
Did she tell, is it your understanding that she actually told Nathaniel that she was going to basically come and take him home that day?
Oh, I'm sorry. Yes, on this occasion, there was conversation that she was going to come and get him and remove him from the hospital, and recalling that last summer on 2 occasions, she removed him from the same Nexus hospital twice against medical advice, AMA. Nathaniel was, his mom told him via the tablet that she was going to come and get him, take him out of the hospital. He was anticipating that. And when the psychiatrist, Dr. Cousins, told Nathaniel that, no, you're not leaving today, he went into an even worse meltdown and had to be restrained by multiple members of the staff, had to be tranquilized. And in this case, Nathaniel was so enraged that he threatened to kill the psychiatrist, and it was even worse. So this meltdown was worse than the previous one. And it was at that point that I decided, and staff concurred, that something definitive had to be done to prevent communication that was upsetting him this way.
Okay. And in that meltdown, did Nathaniel actually, did he scratch staff members? He threw a trash can, tried to break his bed. Is that correct?
Yes, he did scratch hospital staff members on, I think, on the forearms. And I also forgot that in his first violent meltdown, he was allowed to cool down in his room. Remembering it took approximately 2 hours from start to finish. But during his cool down period, he kicked the door to his room and injured his toe, which was badly bruised, and ultimately the toenail came off. He was treated for that, but you know, these things can be serious, and they are very distressing.
And after that second incident, did you learn that, was it your understanding that at this point, Kimberly, Ms. Wright had contacted now the FBI regarding Nathaniel?
I learned that in conversation with Dr. Cousins, that she had told the staff various things, to include that, and I'm getting this, I guess, third hand or second hand, that she had contacted the FBI to say her son had been
what? I'm sorry, you cut out there.
Had been kidnapped.
Okay. And were you advised by Nexus that if this disruptive behavior kept continuing and was being triggered by Kimberly, that there was a possibility that Nathaniel could be discharged from the facility?
Ultimately, it could happen, not anytime soon, remembering that the Nexus staff is trained and experienced in this kind of behavior. But at some point, yes, if it continued, that would be an option that the CEO of the hospital would consider.
And under the last orders, y'all were both appointed as joint managing conservators. Is that correct?
Yes.
And at that point, Kimberly still had the right to designate the residents with regard to Nathaniel. Is that correct?
I believe so. Although the orders did empower me to decide as to his medical residential treatment and also his location. And yeah.
And so you're asking the court to designate you as the sole managing conservator with the right to designate the residence for Nathaniel. Is that correct?
Yes, I am. And one thing I need to insert here is that on March 28, Kimberly Wright actually drove the approximately 200 miles from Eagle Creek Ranch subdivision to the Nexus Hospital and went in and said that she wanted to remove her son and that she was empowered to do so under the terms of our 2015 divorce decree. She was told that she couldn't do that now. It was not visiting hours. She came back later. By that time, the Nexus staff had phoned me. I happened to be in Houston. I left my hotel room. I went there and I observed the second encounter in which she was told that no, she couldn't. The house supervisor, the senior nurse on duty, told her that she had court orders from a month earlier that trumped anything that Kimberly Wright had, and that when Kimberly turned and saw me sitting quietly in the reception area, she loudly spoke, Jesus is Lord, something else. Then she had a parting comment to a nurse, said she didn't want this to happen while I was there. Then she got in her car and left. My point being that she has not only tried to disrupt things by telephone, but she did show up in person at least once since I've had Nathaniel back in that hospital.
Okay, and you still want Kimberly to have a relationship with Nathaniel, correct?
Well, yes, of course I do. She is his mother, but she is going to have to come to the table in good faith and understand that Nathaniel needs months and months of treatment there at Nexus, and she cannot behave this way. And she cannot be trusted to have one-on-one contact with Nathaniel, whether internet, telephone, or certainly face-to-face. She has shown over and over that she is a disruptive influence. Nathaniel needs to stay in that hospital at least 6 months. He has to lose 90 pounds of weight. His behavior needs to get under control. He is in a very sound dietary and behavioral program for his Prader-Willi syndrome, and that cannot be interrupted.
And are you asking this court to order that Ms. Wright have some sort of supervised therapeutic visitation with regard to Nathaniel, whether it's in person or even through phone calls?
Ma'am, I have discussed that with Nexus staff, and as far as the supervised visitations or therapeutic visitations, that simply is not in the wheelhouse of the hospital staff. When people visit, there are nurses on duty and so forth, but what we're asking for is a higher level of staff intervention, which the hospital cannot do, and that is the word from the CEO. So Kimberly needs some kind of consultation or therapy or something, but she can't get it in Houston at Nexus Hospital.
But you're asking that this court order that her visitation be therapeutic supervised visitation, whether she obtained that on her own and bring that into Nexus or however she manages to do that. You're just asking the court for Nathaniel's best interest, for his safety and welfare, that the court orders supervised therapeutic visitation with regard to Nathaniel, whether that's in person or on the phone. Is that correct?
Yes, we do need someone monitoring this in real time.
Do you think that it would be in the best interest of Nathaniel that the court order a psychological evaluation for Kimberly Wright as well?
Yes, I do.
And do you think that it is in the best interest of Nathaniel that you are appointed as the sole managing conservator with the right to designate the primary residence for Nathaniel?
Yes, yes, ma'am, I do.
Okay. And since if this court decides to do that, would you be asking the court also, since you are the primary caregiver for Nathaniel, to terminate your child support obligation?
Yes,
And currently Nathaniel's covered under Medicaid, is that correct?
yes, he is.
Okay, and then as far as, would you be asking the court that Kimberly pay child support for Nathaniel to a special needs trust based on minimum wage, since we have no indication as far as any wages that she earns?
Yes, I would.
And why do you believe it's in the best interest that you be appointed as the sole managing conservator with the right to designate the primary residence for Nathaniel?
Well, first off, I am in regular contact with Nexus Hospital staff. I have had lengthy sent down conversations and also extensive sharing of records. I'm on board with what the professionals at that hospital see as his needs according to his Prader-Willi and also autism. Nathaniel's mother, on the other hand, has been defiant with not only those doctors, but others, and simply believes that she knows better than medical professionals. And further, I believe her actions have been, and I am a layman, but I see very irrational behavior at her end.
And to your knowledge, has she been in any contact with Nathaniel's case manager or anything at the hospital?
Not lately, no.
And as far as, contact, as far as trying to learn about how he is, what's going on with him, what his treatment plan is, anything like that?
Well, she did have contact, and I know conversations last summer, July and August, when he was there. But ultimately, again, she removed him from Nexus twice, AMA. And for that reason, she was barred by the CEO from returning Nathaniel to Nexus. It was only when I intervened and assured the hospital staff that, subject to the outcome of district court action in Wilson County, that the staff would be dealing with me alone and that I would adhere to their recommendations regarding his Prader-Willi treatment.
And if she, since the orders were issued in February, has she tried to contact you to find out what's going on or what she could do to help, or tried to work with you with regard to Nathaniel and his treatment?
No, in fact, quite the opposite. She has gone out of her way to avoid contact with me.
Okay. I have no further questions, Your Honor, and would ask that the court grant Mr. Kufis sole managing conservatorship with the exclusive right to designate the primary residence, or if the court finds that that's not in the best interest, that they remain joint managing conservators, that he is appointed as the conservator with the exclusive right to designate the primary residence, that the court orders supervised and therapeutic visitation with regard to Mrs. Wright's contact with Nathaniel, that the court terminate Mr. Kufis's child support obligation and order that Kimberly Wright, based on minimum wage, pay child support to a special needs trust for Nathaniel Kufis, and order psychological evaluation for Kimberly Wright, Your Honor.
All right, I've listened to the evidence carefully, and I've taken judicial notice of the previous testimony and filings. I will make all the necessary findings. I will continue the parties as joint managing conservators, but grant all of the other relief sought. That may be a distinction without much of a difference, in that this right is not going to have the ability to exercise much in the way of joint managing conservators' rights under these temporary orders, but I will grant all of that. And ask you to let me know whenever you have are you going to email an order or e-file?
Yes, I'll e-file the order, Your Honor.
Okay. All right. Okay, and I wish all good luck.
Thank you, Your Honor. May we be excused?
Absolutely.
Thank you.
Okay, who else is ready to go on something?
Your Honor, this is Tammy Pfeiffer in the
Yes.
divorce.
Let me pull the divorce files. Give me a moment to look these over.
Yes, sir. All right, I think actually Mr. Petrie was first. Let me pull that file. I got the Presley and not the Petrie. Okay, and while we're waiting, Dennis Smith, is he in custody? The criminal side?
Yes, sir, he is.
Okay, if you could meet with him in a breakout room and go ahead and get the verification, I would appreciate it. And then just send me that page in chat, or email actually would be better. I know I'm switching what I said. I haven't been able to get I got my Acrobat going, but it did not, somehow it erased my digital signature and everything, so I can't sign documents right now. And I have to work on that.
Let me know if you need me to bring you hard copies of any of it. But Kelly, can you please get Dennis Smith? Lori, can you put me in a breakout room with the jail?
Okay.
Yes, ma'am. Let me call for him.
Yes.
All right, so I'm calling in the matter of the marriage of Petrie. But Ms. Pfeiffer, you and your husband are both present also, is that correct? Yes.
Yes, Your Honor.
All right, I will swear everyone in a minute, but we have Tammy Pfeiffer, Melvin Pfeiffer, and Jacob Petrie present. I need to tell everyone that you've presented me with pro se or self-made divorce decrees. I need to tell you that in Texas, the law presumes that every single thing a married person owns is community property. The moment you say I do, the law just assumes whatever you have is community property. And in a divorce decree, if the divorce decree itself does not either say, yes, this particular piece of property is community property, or, and here's who gets it, or it doesn't say, you know, there's another piece of property that was inherited or owned before the marriage, or for some other reason, it's not community property, therefore it's not being divided up. If that does not happen, then the law presumes that the judge forgot to divide the community property and that the ex-husband and ex-wife still own the property together, even though they are now divorced. And decades from now, the ex-spouse or the creditors of the ex-spouse can come back and they can say, wait a minute, the judge forgot to divide something and we want our half of it. That is true regardless of whose name is on the property. It's not a matter of whether y'all are fighting over it right now. It's not a matter of whose name is on something. If it's valuable enough that there might ever be a lawsuit over it sometime in the future, we need to make certain that it's spelled out in the divorce decree who gets it. So Mr. Petrie, I'll ask the Pfeiffers to ponder that while I prove up the Petrie divorce. Mr. Petrie, would you raise your right hand? Do you solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God, Your Honor.
And your name is?
Jacob Petrie.
All right, and Mr. Petrie, you are married to Alyssa Petrie?
Yes, sir.
And has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Just different interests. Yes, sir.
Okay. Is there any likelihood that the two of you are going to reconcile and live together again as husband and wife?
No, sir.
And prior to the time this lawsuit was filed, had you been a resident of Wilson County for 90 days and of Texas for 6 months?
Yes, sir.
And when did you and Miss Petrie marry?
It was March 17th of 2007.
Okay. And how many children have been born to Miss Petrie since that day?
Just one, Your Honor.
Okay. And to your knowledge, is she expecting a child?
No, sir.
And have the...
She's on, Judge, as well.
Oh, I'm sorry.
Yes, she is
Alyssa
on.
Petrie?
She's unmuted and
Yes,
I'm not
Your
sure
Honor,
if it
I'm
is.
here.
All right. Would you speak up again? You're not popping up on my screen.
Yes, Your Honor, I'm here.
Okay. And your name is on there too. Okay, hold on. Let me move you around. All right. I have a little message box that pops up from Zoom that says 14 unassigned participants. That's a message box about breakout rooms, and that was over your name. All right, so Ms. Petrie, are you ready to proceed?
Yes, Your Honor.
All right, and do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. All right. All right, and Mr. Petrie, you've given me a proposed divorce decree with both a marital settlement agreement and a schedule for possession of your child attached to it. Do you believe that the proposed schedule for conservatorship and possession of your child is in your child's best interest?
Yes, sir.
And there's an amount of child support that's been set. Is that based on the guideline child support from the Texas Attorney General?
It is, Your Honor.
All right, and you heard what I said to both of you about marital property and community property.
Yes, sir.
I see that, I believe there's a mention of retirement in your marital property agreement, but I do not see automobiles, businesses, cows, tractors, bass boats, anything else described. Is there anything that should have been described in your marital settlement agreement?
I just recently had bought a new truck, Your Honor.
Okay. And are there any automobiles described in this?
There is not, Your Honor. I got the truck after I had created the paperwork and I did not correct it.
Okay. And what sort of automobile or truck did you buy?
It's a GMC Sierra 1500,
Okay. What year?
2019.
All right, and can you think of anything else?
I have a joint property in Baytown, Texas, and I didn't think of putting that on there also. It's when my grandfather passed away.
All right, so it sounds like it's your belief that that's your separate property because you inherited it, or was it?
Yes,
given
sir.
you okay.
I didn't think of putting on there because I thought it was an inherited property. I didn't know if I should have put it on there or not.
And again, I'll say for all the parties, it's not a matter of that you couldn't probably win the lawsuit in the future if somebody, if your ex-spouse gets in a wreck and it has $1 million judgment taken against them for, automobile wreck. You probably would win the lawsuit, but you might be good to be in a position where you don't have to because it's spelled out. All right.
Yes.
All right. So Ms. Pfeiffer, let me ask you, have you heard everything I'm sorry, Ms. Petrie, did you hear everything that your husband testified to?
Yes, sir.
Okay. And do you have any questions for him right now?
No, I do not.
Okay. Is everything he said true and correct?
Yes.
And are you expecting a child at this time?
No, I am not.
And can you think of any property that needs to be described in your marital settlement agreement?
No, sir, I cannot.
Okay. And do you have an automobile right now?
Yes, sir, I do.
Okay. Who owns
Each
it?
of our automobiles are in our own names.
Okay, again, it doesn't matter whose name it's in. It's still
Okay.
community property. The law presumes it was community property, even if you owned it before you were married. If it was purchased during the marriage, it is absolutely community property unless you can show that you purchased it, say, with money you inherited. So it's community property. And you don't have to do it, but it would behoove you if it was described in your marital property agreement. So
Okay.
do the two of you have email access to each other?
Yes, sir.
Yes.
Okay. What I would suggest that you do is, if you will just create an email that says, here's the automobiles that are community property that are being awarded to, and who they're being awarded to. And that also says that if that's correct, that Jacob Petrie's property in Baytown is his separate property. And then post that in chat. I will incorporate that in the divorce decree. You don't have to. Do you want an opportunity to do that?
I don't have access to my email at this time, Your Honor.
Okay. Ms. Petrie?
Yes, I can do that.
Okay, well, I will be on here for quite some time, it looks like. So what I'll do is I'll just wait for someone to come back and post that in chat, and then I will add it to your divorce decree. Okay.
Yes, sir, I can do that.
All right, thank you. All right, and you're asking to have your previous name restored to Brian?
Yes, Your Honor.
Okay. All right, anything else on either side? No? Okay, I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. There is a waiver of citation in the proper format that's been filed by the respondent, and she has also appeared here in open court and announced ready. Mr. Petrie had been a resident of Wilson County for 90 days in Texas for 6 months before the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities. There's no present likelihood of reconciliation. There was one child born during the marriage and no other children were born, adopted, or expected. I find that the proposed orders concerning that child are in the child's best interest, and I will approve them. I'll find the proposed division of the marital property and debts is just, fair, and equitable. I will approve that. And I will restore the respondent's previous name. Pronounce the divorce in open court, just subject to that email to be attached to the marital property agreement. All right, I wish you all good luck. And I believe I saw on one of these, I saw yes, we have the Bureau of Vital Statistics sheet has been filled out. Okay, so the two of you are excused, subject to getting that back to me.
Yes, sir. Thank you, Your Honor.
You're welcome. Give me just a moment. All right, calling in the matter of the marriage of Pfeiffer. Are both sides ready?
Yes, sir.
Yes, sir, Your Honor.
Okay. Let me ask both of you to raise your right hands. Are you driving, ma'am?
No, I'm just sitting.
Okay, good. All right, let me ask each of you to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, Your Honor.
All right, and Mr. Pfeiffer, can you start your video?
For whatever reason, it's not wanting to work.
All right, do you have a button popping up that says the host has asked you to start your video?
No, sir, I don't see anything.
Okay. All right, so before we go any farther, let me ask the parties, now that you've heard me discuss community property and that everything is presumed to be community property, do you need to go back and do anything to your divorce decree to add or subtract any definitions of property to make sure you all have clear title to it?
No, sir. It should be good the way it's written.
Mr. Pfeiffer, do you agree?
Yes, that's correct.
Okay. All right then. Ma'am, before you filed this lawsuit, had you been a resident of Wilson County for 90 days and of Texas for 6 months?
Yes, sir.
And you are married to Melvin Javier Pfeiffer?
Yes.
Okay, or does he pronounce it Xavier?
Either way is fine.
Okay. All right, has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Yes.
Is there any present likelihood you're going to reconcile and live together again as husband and wife?
No.
When did you and Mr. Pfeiffer marry?
November 11th, or November 12th, 2004.
Okay. And since the date of your marriage, is Devin Pfeiffer? Sorry?
It was November the 12th, I believe.
All right. And since the date of your marriage, you've had one child born to you?
Yes, that's correct.
Okay. And have you adopted any children?
No.
Are you expecting a child?
No.
Okay. And let me look at your proposed divorce decree. Okay, and you're asking that you be appointed the sole managing conservator of the child,
Yes, sir.
and that there be standard visitation?
Yes.
And that you provide the healthcare insurance for the child?
Yes, sir. I'm retired military.
Okay, and that Mr. Pfeiffer not pay any child support at all?
That's correct.
Why is that?
Well, he owns his own business and it's kind of, it's kind of hit or miss, and Devin's almost 16 and I just don't really need it.
Do you think that's in the best interest of your child?
Yes, sir. I can completely provide for him. No problem. I work full time. I'm retired military. It's not a problem.
And I'm looking here. Your husband's being awarded, or he has separate property that's a piece of real property in Eagle Pass and 2 Plymouth Dusters.
Yes, sir. The land was awarded to him, or was gifted to him by his mother.
Okay. And then on community property, there is a house in Oak Hollow Estates that's being awarded to you, and also 2 vehicles.
Yes.
And your husband gets 100% of his retirement, and you get 100% of your retirement,
That's correct.
and you each pay your own debts after January 7th, 2021.
Yes.
And I'm looking here. And then there's 3 loans or accounts that are they in both of your names that are being paid by Mr. Pfeiffer, and 1 that you're paying, or 2 that you're paying?
So we have 2 accounts. We have a USAA account that's a checking account, and we also have a Chase account that's a business account. And we're both on each one. Eventually after divorce, we're going to take each other off of those accounts. But right now we're still on both of them. And the loans, one of the loans in the USAA is actually for the truck for the business. So until it's paid off, it's kind of still both our responsibility. Basically, he's given me the money to pay the loan.
Okay, and which one is the truck loan?
It's the USAA loan that's under his, it's listed under his responsibility, I believe.
Okay, yes,
It's a signature loan.
the
Mhm.
signature loan, okay.
Yes.
All right, and do you think that's a fair way to divide your property and debts?
Yes, sir.
Okay. And you're not asking for a name change?
No.
Okay. All right, Mr. Pfeiffer, do you have any questions for your wife at this time?
No, Your Honor.
And did you hear everything that she testified to?
Yes,
And is that all true and correct?
correct. Yes, sir.
Mhm. All right, anything else from either side?
No, sir.
No, sir.
Okay, I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. There is a waiver of citation or an answer. Yeah, there's a waiver of citation on file from the respondent. There is also, he has appeared in open court and announced ready, and he has signed off on the divorce decree, indicating his agreement with it. The case, as I said, has been on file for more than 60 days. The marriage between the parties has become undermined due to a discord or conflict of personalities. There's no likelihood of reconciliation. The petitioner had been a resident of Wilson County for 90 days and of Texas for 6 months prior to the time this lawsuit was filed. There was one child born during the marriage and no other children were born, adopted, or expected. And I will find that the proposed orders concerning the children or the child is in the child's best interest, and I will approve it. And I'll find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. I will pronounce the divorce in open court. Any relief that does not appear in the divorce decree is denied, so this is a final appealable order. And I see that the Bureau of Vital Statistics sheet has already been filed. So that concludes this matter. You will be able to get a certified copy of the divorce decree if you need one later this week. Wish all good
Thank you,
luck,
sir.
and you're excused.
Thank you.
All right.
Excuse me, Your Honor.
Yes, sir.
I just wanted to, we had email correspondence with Alyssa now, and she's going to send that to the chat.
All right, thank you.
Yes, sir. After that is done, are we excused?
Yes, sir.
Thank you, sir.
All right, Ms. Barrera, give me a minute. I'll get your order.
Yes, sir.
All right, so this is a final judgment.
Yes, Your Honor.
All right, and Paul's. Give me a moment, I'm working on two computers here. All right, Ms. Kruger, I just emailed you the signed order in Balmos.
I'm sorry, Judge, you said you emailed it to me?
Yes, like I said, this is my old
Okay.
laptop that I had to get going again, and I had to reinstall Adobe, and it did not import my digital signature or my stamps or anything else. So.
Okay, I've got it. I'm sorry, I was looking in chat for it. Okay, I've got it.
Okay, what else do we have?
We're ready on the plea if Sean King Dawes is ready. And defense.
All right. Mr. Keendawes?
I'm here, Jan. I'm sorry. I was I'm also on Judge Ellison's docket.
Yes, I have. So are you talking with him right now, or?
Oh, no, we're fine. So I have Mr. Moreno. That's set for a bond reduction.
All right, well, let's go ahead and get the Smith plea done, and then we can look at that.
Oh, perfect. Thank you.
Okay, Kelly, you still have Mr. Smith there with you?
Yes, ma'am. Here he is.
Okay, give me a moment. Okay, calling State versus Dennis Lee Smith. Are both sides ready?
State's ready, Judge.
Defense is ready, Your Honor.
Okay, are you Dennis Lee Smith?
Yes, sir.
All right. Mr. Smith, can you speak, read, and write the English language?
Yes, I can.
And are you the same Dennis Lee Smith who on or about March 11th, 2019, was placed on deferred adjudication probation for the third-degree felony of tampering with evidence and the state jail felony of possession of a controlled substance?
Yes, sir.
You understand that on that day, the judge found there was enough evidence to say that you were guilty, but did not do so. Instead, the judge placed you on deferred adjudication probation. And if you successfully complete that, the case against you will be dismissed. but the state alleges that you have violated the terms of your deferred adjudication probation. And if they can show that that is true, then you could be found guilty today and you could be sentenced to anything that is a legal sentence for those offenses. That is on third-degree felony, 2 to 10 years confinement and a fine up to $10,000. And on the state jail felony possession case, 180 days to 2 years confinement and a fine up to $10,000. Understand that?
Yes, Judge.
All right, specifically, the state alleges that you violated rule number 25 of your deferred adjudication in that you failed and refused to attend, participate, and successfully complete the substance abuse outpatient program as directed by your community supervision officer. And specifically that you were discharged on January the 13th of 2020 for non-compliance. So do you understand what the state is alleging that you did wrong?
Yes, Judge.
All right. Okay, give me just a moment.
I believe you ordered it, Judge. We just had a bond hearing. I believe the state asked for it, and
It's going to be a moment. Give me a moment.
Mr. Cedillo, if you can go to breakout room 8 with Miss Sherhart, please.
Okay. We're going to take a break whenever I finish this because I just realized that I'm not able to actually show the plea papers to the defendants because they're on a different computer and I have to email them back and forth to myself. All right, sir, I've shown you some documents here that are titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. Let me ask you, is that your signature on page 3 where it says verification or?
Yes, sir.
And do you swear or affirm that everything that appears above your signature on verification is true and correct?
Yes, sir. Yes, sir.
And did you also sign with the plea bargain agreement?
Yes.
Right here? Okay. On page 2 of the written waiver of time to file motion for new trial,
Yes, sir.
and on the court's certification of appeal. Right there.
Yes. Yes, sir.
Okay. Did you read these documents yourself, or did your attorney, Mr. Keendaws, read them to you before you signed them?
Yeah, they were read. Yes.
All right. Did you understand these documents before you signed them?
Yes, that's all the charges, right, against me, they're running concurrent, sir.
All right, Mr. Smith,
Yes.
right now, I'm just going over making
Yes,
sure that
sir.
you sign these documents. I have to tell you, all I know about what charges you have is what's been what I've been handed or emailed. this
Okay.
morning. So I don't know
Yes,
if there's
yes.
anything else.
Yes, that's good.
All right, so did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Keendaws has done for you?
Yes, sir.
Okay. Counsel, do you believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
And do you also believe that, actually, that's it, okay. All right, I will accept the waivers in this case. I'll find sure that you made them knowingly, intelligently, and voluntarily, and I will approve and accept them. And I'll ask you, to the allegation that you violated rule number 25 of your deferred adjudication probation by not successfully completing outpatient treatment, is that true or not true?
Yes, sir.
I need you to either say that it is or is not true, please.
Is.
Right. Has anyone promised, I'm sorry. Sleep deprivation too. Okay. I'll accept your plea of true and ask what evidence the state has to substantiate the violation.
Your Honor, we offer states one and its attachments and each counts respectively.
No objection, Your Honor.
All right. Without objection, states one and its attachments are admitted in both counts. Do both sides rest and close at this stage?
Rest and close, Your Honor.
Defense rest and close.
Okay, I'll find that the state has substantiated the violations and also that a change needs to be made in the disposition on this case. Are both sides ready for that hearing?
State's ready, Judge.
Defense is ready, Your Honor.
All right. Is there a precedence investigation or a waiver of one?
We waive it, Your Honor.
Okay, what is that? What are the plea bargains on these charges?
Your Honor, in count one, it's 2 years TDCJ, credit for 144 days. In count 3, it's 12 months state jail, credit for 141 days.
That is correct, Your Honor.
All right. And Mr. Smith, did you hear what was read in the record by the state's attorney?
Yes.
Okay, is that your agreement with the state?
Yes, I believe so.
Well, I need to be certain that
Yes, sir.
that is your agreement, okay?
Yes, sir.
Okay. All right, did the state's attorney add anything or leave anything out?
Dennis?
Mr. Smith, was there anything else that should have
I'm
been?
sorry. No, sir.
Okay. Okay, anything else from either side?
Not from state, Judge.
Nothing more from the defense, Your Honor.
Okay, I'll find that I have enough information to make a decision without a precedence investigation. I will follow the plea bargain agreement in this case. I'll find you guilty of both charges of third-degree felony tampering with evidence, state jail felony, possession of a controlled substance, and sentence you to 2 years confinement on each case, plus the unpaid portion of the court cost. Is there any legal reason why sentence should not be imposed now?
There is none, Your Honor.
Okay. All right, then. It is the Order, judgment, and decree of the court that you be taken by the sheriff of Wilson County and transported to the authorized receiving agent in the Department of Criminal Justice. You'll be confined for a period of 2 years. Your sentence will commence today. It will run concurrently with any other sentence that you may be under and with each other. And you will receive credit for 144 days that you have spent so far in jail on each of these charges. Okay. And you understand, sir, that because I have followed the plea bargain agreement in these cases, that you have waived the right to appeal and you may not appeal?
Yes, sir.
I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you have waived the right to appeal as part of a plea bargain agreement. All right.
And just to,
yes, sir.
and just to clarify, it's 12 months on the state jail. I
Oh,
think you
I'm
said,
sorry. I thought it was 2 on each. Okay.
no, it's 12 months on the state jail.
All right. And that'll be for 12 months in the state jail felony and 2 years on the other.
Right. Thank you, Your Honor.
All right. Give me just a moment here. And I see that, was Lynn supposed to hear this originally, or did he and I swap days today? It just has his name on the judgments. I'm removing that.
Oh, okay. Yeah. My, actually, yes, I believe that's correct. It might have been.
And do we have thumbprints?
Kelly is getting the thumbprints at the jail. I sent the thumbprint page with Kelly there.
Okay, I'll wait for those. All right, give me just a moment. All right, I'll send that all as one package. Okay, what else do we have? It's ready to go. All right, Ms. Shearhart, you and Mr. Cedillos need a breakout room?
I put them in one, but I'm not sure where Mr. Cedillos is at.
He's right here. He's talking, but.
Right here.
Oh, there he is. I put him in a breakout room. I don't know. I can put him back in another one.
Okay, do you still need one?
Yes.
All right, then I'll.
And Your Honor, may I approach?
Yes, sir.
Okay, on Nicholas Moreno, I had set that for a bond reduction hearing. I guess that would be in the afternoon.
No, we can do that now.
Okay.
Are your witnesses ready? Is the state ready?
State's ready, Judge. If I remember correctly, this is a continuation of a previous hearing that you heard.
Okay, and why did I ask to have it brought back?
Because, yeah, you had asked for, I guess, proof that he was going to be working with his brother. And,
okay, yes.
So let me just call him real quick. I sent him the link. Okay, you should be logging on now.
And Your Honor, I just emailed you that original motion on that, for the bond hearing.
Thank you. All right, do we have any other announcements while we're waiting for him? And we'll need Mr. Moreno at the jail once we get the Smith fingerprints.
Your Honor, I'm gonna step out to go grab Moreno, okay?
Certainly, go ahead.
Here he is, Your Honor.
All right, thank you. We have to wait for our witness now. All right, Ms. Shearhart, Mr. Cedillos, were you able to get to a breakout room in your back or you haven't made it?
Yeah, we're back.
Okay,
We're back. Judge, we're gonna ask if we can come back about 1:15, 1:30, when you get back from your lunch break.
okay. Well, I don't typically take a lunch break, but yes, we can come back then if you need to.
About 1:15. Here's what we have. We have a foreclosure going on this divorce. We're trying to work through that, prevent that from happening.
Okay,
So we're gonna talk to the attorney that's handling the foreclosure proceedings.
okay, that sounds fine. Well, let's call it 1:30 then, because I've got some computer issues that'll give me time to maybe get those resolved.
Okay, Your Honor.
Thank you, Judge.
Okay.
Miss,
Stephanie, I'll conference you in, Stephanie.
I'm sorry. Your Honor, my client is having problems with the Zoom. What is the number for him to call in?
All right, and I need to put you all on hold. Give me a minute.
Okay.
Hold on a second.
Cindy, do you know the number to call in?
Yes, I was pulling it up. Are you ready?
Yes.
1-346-248-7799.
Okay, 346-248-7799.
Yes, you understood me.
Mr. Dahl, somebody just came in on an iPhone. I don't know if that's the person you're looking for. Who are you looking for?
Mr. Keendalls, was that your?
Okay, yeah, he's in. That's him. Okay. Robert, can you announce yourself? Robert?
Yes.
There you go.
Can you hear me?
What is your name, sir?
Okay.
What is your name?
Robert Hernandez.
Do you swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Are both sides ready?
State's ready, Judge.
Defense is ready, Your Honor.
All right. And is this a Wilson or Atascosa case?
Wilson.
Wilson.
All right. Go ahead, Mr. Keendalls.
Thank you. Okay. Robert, how are you related to Nicholas?
He's my brother. He's my younger brother.
Okay. Now, what kind of work do you do?
I'm in construction.
Okay, and how long have you been in construction?
Oh, all my life.
Okay.
I've been with this company for the past 2 years.
Okay, so do you work for someone or do you own your own construction company?
No, I'm working for somebody.
Okay, so when you say construction, what exactly do you do?
Right now, we're working in Lavernia on some privacy fences.
And when you say working, is it just putting up the fences?
Yes.
Okay. Now, you say you've been working with that particular employer for 2 years?
Yes.
Okay. And are you saying that you would be able to get a job for Nicholas once he's out?
Yes.
Okay. Now, how much does it pay?
On the laborers, like somebody like him, he'd be averaging about $13 to $14 an hour.
Okay. Okay. Now, are you aware of the situation that he's in right now in Wilson County?
Yes.
Okay. Now, and you're aware that he has 2 charges. Is that correct?
Yes.
Okay. Now, of course, the big one is an ag robbery where that bond is $180,000.
Yes, sir.
Would you and your family be able to bond him out at that amount?
No, sir.
Okay. Now, how much do you earn?
Me?
Yes. How much? Yes.
I make $1,200 a week.
Okay. So if the judge does reduce bond, would it be you and your family who would be trying to get the money to make that bond? Hello? Is he gone?
I don't see him.
Jeez. Hopefully he'll just come back.
All right, and let me ask, at the previous hearing, had I seen a copy of the offense report?
I don't know. Go ahead. I don't know if that was introduced, Your Honor.
I don't believe so either, Judge.
Okay. So, Mr. Keendall, would you have any objection, just for the purposes of this, to my seeing the whatever offense reports Mr. Leday and you have looked at? Because, I mean, aggravated robbery can cover a wide range of alleged behaviors, from, you know, sticking up the bank to you're in a dispute with your friend over who owns something and you put your hand on your knife.
Right. No, no objection, Your Honor. And of course, the regular rules of evidence
don't apply.
Usually don't apply, yes. Let me just call it one more time. I mean, I was almost finished anyway. Okay, it's going to voicemail now. Your Honor, I think I had enough. I mean, unfortunately, the state doesn't have an opportunity to cross-examine him if they wanted to. But it was really just to establish that he has work once he's released. And of course, he has ties to Wilson County.
All right, Mr. Leday.
Well, I wasn't intending on asking questions, Judge, but I mean, I can waive them for the benefit of expediency.
People are coming back at 1:30.
Well, we're coming back anyway.
Can I do anything for you? Can I heat something up for you? I didn't bring anything. What? You don't like anything from Cerritos? You don't like their food? Well, you want me to sit here? You go
And
grab you something?
Is someone going to email?
You
or-
go read.
I'm
We're
working.
going to bring me back some flautas. Okay. Oh.
Okay. I need to get in touch with an officer from Frio County on a search warrant. So let's be back at 1:15. We'll take this up before the divorce case. Mr. Andrews, did you have anything briefly, or Ms. Starling?
I only had two items, and it was just to one of my clients is gonna need one more setting, and then I wanted to make sure that Kenneth Carlisle, we got the court understands what's being done with his case.
Yeah, I have no idea what's going on with Mr. Carlisle's case.
There was an agreement with Mr. Leday to extend and sanction for 3 days, and it was an agreed. It was an agreement.
Okay, just get that order to me.
Yes, Your Honor.
Okay, Ms. Starling, did you have anything?
Your Honor, I'm just here to assist Mr. Akindas if he needs
Okay.
any of my help.
Okay, all right, well then I will be back at 1:15.
Okay, thank you, Your Honor.
And then, and I'll look for the offense report.
I just sent, it, Your Honor.
Okay, where do we stand? Mr. Keendos?
Yes, sir. Your Honor, I'm here.
Or shooting at you. All right, were you able to get your witness back?
He did call me. See if you give me 1 second, Your Honor.
All right, that may be him coming in.
Your Honor, you're gonna need Moreno again so I can go get him?
Yes, please.
Okay, I'll be right back.
Mr. Cedillos, did you and Ms. Shearhart have an announcement?
Yeah, let me talk to Ms. Shearhart one more time.
Okay.
Do you need another breakout room?
Yes.
All right, I'm asking the Galaxy Note to unmute. Okay. Who is here on a Galaxy Note? On a telephone, I'm asking you to unmute. Who? I can't understand anything you said, literally. All right. All right, let's try it one more time. If that doesn't work, you're going to need to log off. You're gone. Okay. All right, if you'll tell me when Mr. Moreno gets there.
Yes, Mr. Hernandez is back here.
Okay. All right, I'm asking you to unmute, Mr. Hernandez.
Can you hear me?
Yes, all right.
Okay,
Are you
because I can
driving?
barely hear y'all.
Okay, are you driving, sir?
No, I'm parked.
Okay, okay. All right, go ahead, Mr. Kindos.
Okay, okay, so last we left off,
Yeah, he's there. He just can't hear. That's what we're.
oh God. Okay, Mr. Hernandez, Robert?
Yes.
Okay, you're there. Okay, good. All right. So last we left off, you said you gross 1,200 a week, is that correct?
Yes.
Okay, now, how long have you lived, you and Nicholas lived in Wilson County?
All my life. I've been in Wilson County for 41 years.
Okay, good. And your parents are still here too?
Yes.
Okay. Now, what did you guys go to the same high school?
No, well, yes, but he's younger than I am.
Okay. And so what high school did Nicholas go to?
Floresville.
Okay. Let's see. Now, you said you would help with the bond. Is that correct?
Depending on the amount of the bond we have to pay, yes.
Okay.
Because we really don't have that much money. You know what I mean?
Right. Okay.
If there was another way without having to pay a bond, if we, you know, y'all had talked about putting them on that monitor and paying the monitor, you know, that would be easier for us than to pay the bond.
Okay. Now, if he's out on bond, who will he live with?
With my mother.
Okay.
He's gonna stay with my mother. I'll be picking him up around 6:15 to 6:30 and dropping him off around 5:30 to 6:30.
Okay. And which leads to my next question. Would you be able to assure the court that he wouldn't reoffend or just take off and go to parts unknown?
Yes.
Okay. Pass the witness, Your Honor.
Mr. Lede?
Thank you, Judge. Now, Mr. Hernandez, what fencing company do you work for?
Well, I work for Brush Country Contractors.
Okay. And let me ask you a question. That when your brother was first arrested, the bond was only $75,000. Did you help pay for that?
No, I didn't.
Okay. And you know that it's so high because he missed court, right?
Yes, sir.
Okay. And when you drop him off at his mother's house, you're not going to see him for another 12 hours, right?
Yes.
Okay. So you're not going to be able to have any ability to babysit him, make sure he comes to court, or what he's going to be doing in his free time, right?
Yes and no. My mother will be there with him. That's why I'm saying I'll leave him there at 5:30 to 6:30 because that's what time she gets home.
Right. Well,
and she don't leave till 6:30 in the morning.
And you understand he's on our docket for 2 separate felonies, right?
Yes.
Okay. So, I mean, you know, with all due respect, and it's not y'all's job to babysit him, that your mother or you or whoever else hasn't been able to stop him from committing 2 separate felonies.
Well, the whole thing is this, that at that point that he committed these, he didn't live with neither one of us.
Okay.
You know, he was staying somewhere else.
Okay. But I mean, if he decided he wanted to go out and leave, there's really not much your mom can do about it, right?
Oh yeah, there is. Because we won't hesitate to call the cops and just have him rearrested.
I'll pass the witness, Judge.
As fast as we don't see him.
Okay. No further questions, Your Honor.
Okay, anything else from the defense?
Your Honor, I'll call Nicholas Moreno.
All right, Mr. Moreno, I don't believe you were sworn last time. Let me ask, do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, go ahead, please.
Thanks. Okay, Nicholas. The last time when you were out on bond, where did you go?
I left out of state to go work.
Okay, now, during that time from, and I'm not gonna go over, the whole issue of, we talked about the issue of why the bond was revoked, but during that time that you were in Minnesota, when did you find out about the bond revocation?
Well, I didn't find out about the bond revocation, but I had called the courts like about a week ahead of time before my court date to let them know that I wasn't gonna make it. And then by the time I had got back into town, they had already revoked my bond because I was out on PR bond.
Okay, so do you remember what month this was, of what year?
I believe it was like in October, somewhere around there.
Of what, 2019?
Yes, sir. And I got brought in November of 2019.
Okay, so during that time, do you remember when you had bonded out originally?
I believe I had got out like in January, but I PR bonded out on it. I didn't have to pay my bond.
Okay.
I sat here for 90 days, and within those 90 days, I didn't get indicted, so they gave me my PR bond.
Okay, so you were out originally on a PR bond on the Agro. Is that what
Yes,
you're
sir.
saying? Okay.
Yes, sir.
So you were taken back into custody November of 2019. Is that correct?
Yes, sir.
And you've been in custody ever since, correct?
Yes, sir.
Now, during that time, did you commit any, during the time from January to when you were arrested again, did you commit, other than the evading arrest, did you commit any other offenses?
No, sir.
Okay. Now, July of this year will be 2 years you've been incarcerated. Is that correct?
November of this year. Yes, sir.
Okay. Thank you. Right. November of this year. What has been the effect of this continued incarceration?
Pretty much I haven't been able to work or make any type of money or anything like that. And plus I haven't been able to pay my child support or anything like that. I have 2 kids that I do pay child support for. And I mean,
how old are they?
My oldest just turned 13 on Saturday and my youngest is 8.
Do they live with mom?
Yes, sir.
Have you seen them at all?
Like maybe 2 or 3 times since, because the fact that they set up some video visits here or whatever due to the coronavirus.
Mm-hmm. As far as you know, how is mom doing? As far as financially?
Financially, I mean, I believe they're good, but I know my daughters, they both got sports that they're in, plus cheerleading, and I know it's rough for her out there.
Okay. Now, let me ask you this. Given your financial resources, how much of a bond could you afford?
I'm right now, nothing really. I was maybe hoping that the courts would maybe reinstate my PR bond for the fact that we got to pay for the ankle monitor. And I believe the ankle monitor is like $500 just to get started and $300 a month after that. I know they're barely able to come up with that money.
Okay. And it is your intent to fight your case?
Yes, sir.
And
we were supposed to have already went to trial last April.
Okay. So if you're given a low enough bond that you can make, what assurances can you give this court that you're just not going to take off and hide somewhere?
I mean, for one, I'm gonna have an ankle monitor on me, and 2, like my brother said, him and my mom, they're willing to call the cops if I'm messing up at any point in time, just to rearrest me, and 3, like I'm fighting my case. I'm willing to take my case to trial, and I mean, I wouldn't be wanting to go to trial if I was just gonna run.
Now, you brought the issue of the ankle monitor. So are you saying that you would agree to an ankle monitor? Is that what you're telling the court?
Yes, sir.
Now, you do know that there is a cost associated with the, I guess, ELM or ankle monitor. Are you aware of that?
Yes, sir.
Okay. And you think you would be able to make that monthly payment? I think it's between $200 to $300 a month.
Yes, sir.
Okay. Are you going to pay for it through your job? Is that the intent?
Yes, sir. That's why my brother has a job waiting for me is the day I get out. You know?
Mm-hmm. Now, and have you lived in Wilson County all your life, essentially?
Yes, sir.
All right, pass the witness, Your Honor.
Mr. Ledane?
Thank you, Judge. Mr. Moreno, not counting the 2 felonies you have on the docket, you have 4 prior felonies, correct?
Yes, sir.
Okay. So this would be your 5th and 6th felony, right?
Yes, sir.
Okay, and you got 2 misdemeanor thefts, evading, assault, family violence. Those are all misdemeanor crimes you've had, right?
Yes, sir.
Okay. And so you ever hear the saying that people are what they do, not they say?
Yes, sir.
Okay. And so you have 2 more felonies, and yet you failed to show up to court.
Yes, sir.
I'll pass the witness.
Mr. Diaz?
Just one more question. Okay. You're not denying that you have a past, is that correct?
Yes, sir.
Okay. Given that, are you going to stay in county if you're able to make bond?
Oh, yes, sir.
And did I pass on an offer to you that the state had extended?
Yes, sir.
Okay. And did you reject that offer?
Yes, sir.
Because you intend to fight your case all the way to the end. Is that what you're saying?
Yes, sir.
So therefore, you're not going to leave?
No, sir.
No further questions, Your Honor.
No further questions, Judge.
Okay, does the defense rest or defendant rest?
Defense rest, Your Honor.
Okay. Mr. Ledane, anything from the state?
No rebuttal, Judge.
Right, argument?
Yes, Your Honor. Your Honor, this, of course, that's a long-running case. He was out on bond. He was doing fine. It's just that he made a mistake of going to Minnesota and not being able to come back. And a lot of times people go up north to find work. And that's essentially what Mr. Moreno did. And unfortunately, his bond was revoked. More unfortunate is that his bond was set really high. Now, this is a second motion. So at the first bond hearing, it was reduced a little bit, but it's still way too high. He has extensive ties to Wilson County. He's not a flight risk because he fully intends on fighting the ag robbery case, especially. And of course, he has ties to community. He's been in there a long time. I mean, well, over a year. It will be 2 years in November. That's just a long time. Of course, the whole COVID pandemic kind of made things a little worse for him. So that's why we couldn't go to trial earlier. But he really needs to be out. He has a family to support. And there is no additional reason, to keep him incarcerated further. Like I said, he was doing good on the PR bond. So I would ask the court to give him a PR bond, and he'll agree to an ankle monitor, ELM, to kind of keep him honest. If a PR bond is out of the question, then something reasonable. 15, 20,000. I mean, even then, it would be an effort to get the money up because, and again, we're talking about the 2 cases. So the evading arrest, that's a state jail because it was on foot and he had a prior. So if you could give him a PR bond on that, and then he'll just have to worry about the ag robbery. And I know it is it's a first degree. I understand that. He has a criminal history. I understand that also. So, but given his indigent status and essentially that his family doesn't have a whole lot of money, 15, 20,000 or even below that, would really help him to get out and fight his case. Thank you.
Mr. Lede?
Judge, this bond issue really has kind of a wild history that he originally made bond and his bond was 75,000. He failed to appear in September of 2019. You, Judge, raised it to 250,000. And then later when we had a hearing in March of last year, you lowered it to 150,000 plus house arrest and GPS conditions. Mr. Quindon says, well, he's done really well on his PR bond. Not only did he fail to appear to court, but he committed a second felony. So I would argue that he didn't do particularly well. You look at his criminal history, there's assault, family violence, there's theft, there's drug possession. Certainly they're trying to avail that his family needs him. But if you look back to 2014, which is the last 7 years, he's been nothing but a career criminal who's using drugs, assaulting people and stealing. I think his family has probably learned how to do without him or could do better with him around. I think the 150 is fair given all the circumstances with the house arrest and GPS. And remember, not only does he have a violent crime he's being charged with, but he has an evading, which goes straight to the heart about whether he's willing to comply and come to court. And that's based off a prior evading, which also shows that he is more programmed towards flight than to making his appearances in court. I think the 150 is more than fair, Judge, with the conditions of house arrest and GPS. And the concerns of the community and the concerns of him coming to court outweigh the amount of time he's been in jail.
And how much is the bond on the evading?
20,000.
I'll just say one thing in rebuttal. As far as the evading, that occurred, I guess, when the warrant was being executed, when he was being taken into custody. And I guess as a minority, it's kind of like the flight issue. That's the first thing that came into his mind, is to flee. So I don't think that the court should use that against him. But yes, if the court would really concentrate on whether there's a flight risk, whether he'll reoffend, and his ties to the community, the fact that he'll be able to out there work and help with his kids. And that's it, Your Honor.
Judge, my argument, if his first thought is to flee, then that is somebody that shouldn't be getting a lower bond, especially since he had a prior arrest and conviction for doing that exact same thing.
I will give him a PR bond on the evading, and I will add the house arrest and monitor to the robbery and set that at $100,000. If someone will get me an order, I will sign it.
I'll go ahead and do that, Your Honor. Thank you.
All right, Mr. Briggs.
Did you ask for, Judge?
Richard Briggs.
Yes, Your Honor.
Oh, I know you'd been in court with Judge Ellison or somewhere this morning.
Yes.
Okay.
And I have one client with 2 cases on the docket this afternoon, and my first stop needs to be breakout room with Mr. Lede when he has a moment.
Okay, Ms. Riley is the host, so she can do that.
Are you ready to go ahead and put you on a breakout room now, Mr. Lede?
I am.
Okay. I'm gonna send y'all an invite right now.
Your Honor, I'm gonna go ahead and take Mr. Moreno back to his cell unless you still need him.
Thank you. No, we're done. And did we get the thumbprints on Mr. Smith?
Yes, sir, I got them. They're still here with me, but I did get them already.
Okay, if you could send me a good scan of them, I will incorporate them.
Copy that. Yes, sir.
Mr. Briggs, I invite you to breakout room 3 with Mr. Leday, if you can accept that, please. He's in the room already.
Aaron, we just had those thumbprints forwarded to you right now.
Thank you.
Clerk's office.
Okay, with everything crashing and not being able to use Adobe, basically don't have dockets today. Do we have anything that we're waiting on? Just Mr. Briggs needs to talk to his client when they get into the jail. I don't know if Kelly knows that. And then we're waiting for Cedios and Shearhart to come back. Is that all?
I think so, Judge, other than, well, we already have a nice eye on Derry Lewis, I'm assuming.
Okay.
He's never been arrested on his property warrant. And I don't show that Mike Anthony Nava ever showed up.
That doesn't sound familiar.
That was the one Mr. Baird said he has had no contact with.
Right, yes, no, I don't remember seeing. From
What about Hilario Hernandez Jr.?
He's already reset, Kelly. He's got dates.
Thank you. And who is it they need a breakout room with?
Mr. Briggs may ask for to talk to Bojavan Serta, but he hasn't requested it yet.
Oh, okay.
Oh, I thought he did. Oh, no, he has to talk to you, Mr. Lede. I guess he did.
Yeah, we already talked, Judge.
Okay.
Mr. Briggs wants a breakout room with Bojavan Serta at the jail, he says.
Okay, let me try
If
to.
I'm saying his name correct, I'm not sure if I'm saying his name right.
Yeah, you are. Let me try to find out where they're at.
In the Fernando Cantu case, Judge, on top of page 4, I don't have any notes on that one. With Robert Gere. I don't know if Cindy has notes or.
It is
Yes,
actually.
it was reset.
It was reset?
5/5, 5/12, 6/28.
Okay.
Okay, I am going to log off of this meeting and try and reboot this computer and log in on my other one. I shall return shortly.
Okay.
I hope.
Okay.
All right, Lori. Middle of page 4, Genevieve Salinas. I missed that.
I have a note for 5/5 to plea is what Mr. Anders posted.
Okay, I missed that. I must have been in a breakout room.
And they said Mike Nava is going to be a nice size. Is that correct? He was a no-show?
Correct.
Okay.
So I show page 1, Dari Lewis. Nice eyes.
Yes.
We're still waiting on Bojavan Serta.
Right.
Right, but I don't think there'll be a nice eye on Lewis because he's already got a warrant.
Yes.
So we don't have to do
He's already got a what?
outstanding warrant. He's never.
Oh, I
been
got you.
this original.
Correct.
Okay.
I have received the order for Kenneth Carlisle, Lori. I'm putting that one into the queue.
Okay. What kind of order was that?
It's an order amending terms of community supervision.
Okay.
He's on page 2.
Page 2 on this one. Okay.
So I'm sending that into the queue right now.
Okay. So order to amend.
Community supervision.
Okay. All right. And that'll be disposed of then. Is that correct?
Right.
Yes.
Okay. Perfect. Okay. And you said that's being e-filed?
Yes.
Okay.
I don't have anything else on my docket. That's it, other than Bojavan now.
Okay. I think I just have Bojavan Serta. He's got 2 cases. I think that's it. And then it's just that one civil case, I believe, with Susan
Yes.
Presley, Jeremy Raymond, with Mr. Cedios and Mr. Shearhart.
Yes,
And I
just
believe
that
that's
one civil case.
yes. Okay, good deal. And then let's see, Mr. Briggs is back. Okay, I guess whenever they bring Mr. Startup, Mr. Briggs, I can get you in a breakout room. Okay.
Hey, Cindy or Lori, what do we do with David Mora? Just the next set of dates, 5/5, 5/12, 6/28.
Yes.
Thank you.
You said David Mota, is that correct?
Yes, ma'am.
Okay, yes. Those
What
dates.
about Peril?
Peril, same dates. Shayna Peril, that one?
Yeah, and the
Same
one below,
dates.
Jose
5/5.
Arroyo.
Yes, 5/5, 5/12, 6/28.
Perfect.
And
Thank you.
Arroyo, the same. Cantu, the same on that page. Basically, everybody has the same dates except for that top case that y'all just did. I don't know if there's any dates on that. Or do we need dates on that one as well? Moreno?
Yes, we will.
So I guess, I don't know if Mr.
Sean is still
Dawes
there.
wants to post
Sean,
that. Mr. Dawes?
hello, Sean. Can you hear us talking? He may be doing the Atascosa case or something.
Oh, he might be, yeah.
Pardon me, Lori.
Yes.
What was my breakout room with the jail going to be?
I don't know. I was gonna, you were in 3 with Mr. Leday, but it can be any room. I mean, I can put you, but you can go back to 3 if you want. And I'll put the jail in there, or I can put y'all in a new breakout room number 1 if you want me to.
That would be fine. 3 is fine.
Okay, if you can just go back there, then I'll, once the jail comes on, I'll put them in there as well. I think they're waiting on
Great.
Mr. Serta to get there.
Thank you.
You're welcome.
Hey, Lori and Cindy, on the bottom of page 5, Nathan Morales is the one that is in Bexar County Jail, according to Mr. Vargas. Do you want me to bench warrant him 5/5?
That would be great.
Sure, that was the date we had, I think Vargas posted. So
Perfect.
bench warrant,
Will do.
okay.
And then Mark, on Nicholas Moreno, on this case that's on the docket, the ag robbery, judge reduced it to 100,000.
Correct. Plus ELM plus house arrest.
Okay.
Okay, I got Bojem on here.
That it's not a PR.
Okay, I'm gonna invite you out to breakout room 3.
It's just.
Thank you.
Thank you,
It's
sir.
still,
He reduced the evading to a PR. So the 20,000 is now a PR, and the 150 has the same conditions, but it's now 100.
okay. All right. Thank you.
All right, have we heard anything back?
You can ask about.
Actually, I'm talking on the court on the Zoom.
Have we heard back what, Judge? I'm sorry.
Have we heard anything back from Ms. Shearhart, Mr. Cedios?
I think they're still in a, whoop, I don't know where the breakout rooms went. I think they were still in a breakout room, I believe. I don't see the breakout rooms anymore. I don't know. I guess.
I just made you co-host. Well, whenever I come back, makes me the host for whatever reason.
I got you. Okay.
Okay,
They're still in
I'm
a
just
breakout room, Judge?
Okay. Let me go and join that and see if they're going to need me.
Okay.
Miss Cindy, I'm back on this side. I'm gonna take Miss Serta back to her cell. Y'all need anything else?
No, not that I know of.
Okay, are we on a break right now or what's going on?
That's a good question. Was Mr. Briggs able to meet with his client?
Yes, sir. He just got done right now.
He
Okay.
posted dates on one of the cases. Richard, are you resetting both of them? You need to put the other case.
Yeah, I just need to post the other one, and then I'll
Okay.
I'll post the other one with the same dates, and then I'll be done for the day.
Okay, excellent. All right, I'm going to try to open up my mail right now. Ms. Shearhart and Mr. Cedios say they believe they're close to having an agreement and they're trying to get it finalized.
Your Honor, I'm gonna take Miss Serta back to her cell.
Sounds good, thank you.
Judge, other than the calling of the NISA or Nava, I don't have anything else. Do you need me to hang around for anything?
I don't believe so. All right, Ms. Sawyers, did you receive the fingerprints on Smith?
No, sir, I have not received them. I will call over to booking and see what's going on.
All right, Kelly said he had sent them. I thought he said he emailed them to you, but.
Well, he gives them to Sergeant Reyna typically
Ah.
to email to me. So let me call over there and see.
All right, Ms. Kruger, in my cavalcade of bizarre computer issues, I was able to print the dockets this morning, but it will not allow me to print the Pfeiffer attachment. So I just emailed that to you. It's named,
Okay.
titled, it opens it up, it says it's there, but it says error printing.
Okay.
Thank you. And I'll go ahead and sign the hard copy in here.
Kelly has said y'all are going to be emailing me thumbprints on,
Okay, we already signed this. All right, they said to attach it. If there's anything else I have to sign. Did it come up?
No, sir, it looks like a bad connector. I just need to get it fixed before you all start having in-person court again. Do you know when that's gonna be?
For this county? May the 3rd.
And do they use these very often? Because I noticed the transmitter's not working. The power supply went out. So I need to get that fixed.
I mean, we haven't had anyone here to use them for a year, but I don't remember this being used.
Happen and then have a.
And it has a third option, which is wireless. How does that work, or does it?
So what that was a Apple, an Apple, what's the Apple TV.
Okay.
And it's not back there, but we can put one back there. And basically it's a third input that allows you to basically use the Wi-Fi using a wireless connection to the Apple TV. And then you can broadcast. It does a screen sharing thing.
Okay.
With Apple TV. It's pretty nice. And then you don't have to be tethered to a cable.
Yeah, I mean,
It's a little bit of a latency because there's no wires.
Okay. And we already have one. It's just not hooked up. I have to get another one.
Right. It's not hooked up.
If you put that, there's no hurry. But if you put that on the list, that'd be
Sure. And I owe you an apology, and I hope I didn't create a lot of problems, but I still have not got that form you had asked about a message for. And what happened with that is we went through that election, and we got a new sheriff and stuff.
Right.
And that's been everything. We're making a lot of changes and stuff, and a lot of it's good. They're putting MDTs in the cars now, but I've been focused on that.
MDT mobile video terminal or what?
Mobile data terminal.
MDT, okay.
Yes, sir. And so we're putting those in the cars, and
okay.
And they're starting to, that way deputies don't have to come back to do their reports and stuff. So they're out in the field more. But it has that and just a lot of other changes. It's really been a lot. But it's been good. We also changed out the whole phone system at the sheriff's office.
I didn't know that. Are the numbers the same?
Yes.
Okay, good.
Numbers are the same. I found out that like the number that was published for the driver's license office, no one ever told me, but if you called that number, it just rang and rang and rang. And so I went in there and I asked her, has your phone ever worked? And she says, it hasn't worked for years. Ever since the DPS put a phone in their office, an IP phone, and did something with the number. And so I called Frontier and we got it fixed for that number forwards to the DPS number now. But
I don't know if DPS would appreciate that, but
and a lot of phone, what basically what I'm doing now is because they had an old Nortel Meridian system there, and if you have to go,
I know I'm waiting.
And
them to come by.
We put the 3CX system in, and I call forwarded the numbers to that. 3CA system. So the old numbers work.
Okay,
Judge, I emailed you the fingerprints. It's one PDF, 2 separate pages in there.
all right, thank you. I will try and get those pasted in. Excellent. All right, thanks. I'll get working on these right now. Yes, ma'am.
This is just one of my signs. When you quickly can see what bonds we had. Usually was 5,000. We had one certificate of bailiff. We left it at the same at 5,000.
And did he have to post a new bond or?
Posted a new bond on it. So had the original bond together, not so 5,000. The science pressure all day yesterday, and then all of a sudden my voice just like that.
You know, I don't know what's happened. The last few years, I have not had much problem. Some, but
Well, I know, I haven't either. I've been just going, oh my gosh, you know, everybody probably got allergies, and I really haven't had any, but whatever's going on right now, just.
used to, when I was in high school, college and stuff, the cedar would kill me around Christmas, and then the pecan would kill me in the spring, but it has not been that
I'm
bad.
allergic to ash now, it's even all of them. But they really haven't bothered me for a few years, but this year it's just really.
Move to Lubbock. As long as you're not allergic to cotton,
I'm
you're
not
good.
allergic to dust. I'm not going to.
Oh, okay. Well, cotton or dust. If you're allergic to cotton, that's a bad place to be.
Yeah, I don't think there's any place to go. I think there's- Go with your, doesn't that, it stays exactly where you are. I think she built up a little bit of immune just to some of the stuff that's here.
Hopefully. All right, I will email these Smith documents to you in just a moment. Okay, I just sent the Smith judgments, waivers, and order to withhold funds to Ms. Sawyers. And I signed the one nice side, Mr. Leday. I don't know if you were waiting on that or.
Oh, no, I was just making myself available if y'all need anything. I think that's it though, Judge.
Yes, I think we're just waiting on Mr. Cedillos and Ms. Sherrard.
Okay.
Have a good day.
I'll get back on. Take care.
Your Honor, do you need me for anything else, Your Honor?
No, sir, I don't think so.
Okay, well, thank you, and you have a good day.
We shouldn't need a TRLA either, Mr. Raymond. I believe that's his case. I'm just gonna mute her and work. If someone will let me know when they come back, because I will have the screen minimized and I probably won't see it.
Sure, we can let you know when he comes back, when they come back.
So. You know who the next person that was gonna call was? Was anybody in custody? Because I've been in and out of the breakout rooms.
No, I think there was no more criminal cases, if I'm not mistaken.
Okay, well,
Is that
thank
right,
you.
Cindy?
That's correct.
Kelly, you're free to come back.
Okay, thank y'all. Have a good day. God
Have a
bless.
good day,
Thank you,
sir.
Kelly.
Jeremy, he's represented by Stephanie Touchard, the civil case that Andy and.
Dan?
Sorry, the criminal people are still on there? The two.
TRLA. Dan, are you there? Well, I was gonna let TRLA know that they can leave, but they're not answering.
They just want us to think they're participating.
Oh, one left.
No, I'm just removing them.
Okay. All right. Thanks, Judge.
You're welcome.
I'm gonna get off and leave it on with Paula now. Lori.
And the card number?
Yes,
I forwarded the two motions of bond hearing on Nicholas Moreno into the judge's queue for Judge Wilson to sign.
on Moreno.
Yes.
Okay, I'll go look in there and forward those to him.
All right, thanks.
Thank you. I'm gonna step away just a moment, Cindy. Or Paula.
I'm sorry, Laurie, what did you need?
I'm just gonna step away for a moment.
Okay.
Thank you.
Okay, where do we stand?
Go ahead. Your Honor, we have an agreement, a Rule 11 agreement.
Okay,
Judge, would you like us to e-file that or email it to the court for signature?
it doesn't matter. I'm going through my judge's queue right now. It doesn't, whichever is easier for you.
Okay, then I can email it, e-file it unless you have a preference.
Okay, that's fine.
Okay, will do.
Right, go ahead. Who wants to read it into the record? Or do you want it, or you just don't need to?
I can read it into the record right now.
If you don't need it, that's fine.
Sure, I'll go ahead. All right, so it's going to say in part that petitioner, who is Ms. Presley, will have the exclusive use and enjoyment of the marital residence located at 146 Encino, Torcito, Adkins, Texas 78101, and shall pay all bills, expenses, and fees for same. Petitioner shall notify respondent, Mr. Jeremy Raymond, within 24 hours of vacating the residence so that he may cut off the power at that residence. Respondent will have the exclusive use and enjoyment of his residence located at 428 Tower Trail, Lavernia, Texas 78121, and shall pay all bills, expenses, and fees for same. To the extent possible, the marital residence located at 146 Encino, Torcito, Adkins, Texas 78101 shall be put on the market immediately with an agreed realtor and for a price agreed to by the parties. The parties understand that the house is to be foreclosed on and sold on May 4th, 2021. Petitioner shall have the exclusive use and enjoyment of the 2009 Ford Mustang GT motor vehicle and shall pay all bills, expenses, repairs, maintenance, and fees for same. Respondent shall have the exclusive use and enjoyment of the 2012 Dodge Ram motor vehicle, 1993 Chevrolet 3500 motor vehicle, and 2005 Chrysler Crossfire motor vehicle and shall pay all bills, expenses, repairs, maintenance, and fees for same. Petitioner shall pay her car insurance, cell phone bill, and all bills related to the marital residence during the pendency of this suit. Respondent shall pay his car insurance, cell phone bill, and all bills and expenses related to his residence during the pendency of this suit. Respondent shall continue to cover petitioner's health insurance during the pendency of this suit. Each party shall timely pay all debts incurred in their individual names unless otherwise specifically contained in this agreement. Respondent shall make the minimum monthly payment on the following credit cards: the Exxon credit card, Firestone credit card, and Overstock credit card. Petitioner shall deliver the current monthly statements for each of these accounts by the end of day today, April 19th, 2021, to confirm the current balance on all cards and the minimum monthly payment of same. If the statements confirm a lower monthly payment on any card, respondent shall make the minimum monthly payment on the card. In no event shall respondent pay more than the following amounts on each card per month. On the Exxon card, $30 per month. On the Firestone card, $50 per month. And on the Overstock card, $105 per month. Starting today, April 19th, 2021, petitioner is prohibited from further charging on these three credit cards. Respondent shall pay petitioner the cumulative monthly payment for these three credit cards directly through Zelle each month. Petitioner shall be solely responsible for using the money transferred from respondent to make the minimum monthly payment on these credit cards, as respondent does not have access to these accounts. Respondent shall pay petitioner $700 by cashier's check. Respondent shall deliver the cashier's check to his attorney, who will mail the cashier's check certified mail return receipt requested to petitioner's attorney on receipt. Petitioner's attorney shall then deliver the cashier's check to petitioner. And the parties will attend mediation with Randy always within 45 days of today, April 19th, 2021.
All right, Mr. Cedillos, is that your client's agreement?
Yes, it is.
Okay, do you need either side need an entry date?
I don't think at this time we do yet, Judge, but Mr. Cedillos can confirm that.
Okay.
Hold
Yeah, can we have an entry date, Your Honor?
Okay,
Okay, did you get one from Ms. Riley? Just post it in chat.
okay.
How much time do y'all think y'all need? The 26th, would that work? April 26th
Next week? Yes.
or May 3rd? May 3rd will be an in-person hearing.
April 26th works for me.
Okay.
April 26th. Stephanie, I'm gonna call you on one other issue. That's all we have, Your Honor.
Okay, anything else?
That's all, Judge. May we be excused?
Yes,
That's all, Your Honor.
after somebody posts the date in chat.
Oh, I'm sorry. I can do that. Oh, it went direct.
Okay, that looks good.
Go. Okay.
All right, anything else?
I think that's all.
All right, then I'm going to end the meeting and I will.
All right, great. Thank you, Judge. And we'll have an order.